When Elena's mother was diagnosed with Alzheimer's in 2018, her brother David said he would handle everything. He was closer geographically, he had more time. He already had durable power of attorney. Their mother had signed it years earlier, before anyone thought it would be needed soon. Elena lived 6 hours away, worked long hours, and was grateful. For 2 years, she received monthly updates by email. Everything was under control. When her mother died in 2020, Elena flew home for the funeral and learned, 3 days later, that the house had been sold 18 months earlier. The savings account held $4,000. The brokerage account had been closed.
Durable power of attorney is one of the most powerful legal instruments in American law. It authorizes a named agent to manage another person's financial affairs, including bank accounts, real estate investments, and legal decisions, without any court oversight. When granted to someone trustworthy, it is indispensable. When granted to the wrong person, it is a mechanism for systematic theft that can be nearly invisible until it is too late.
Over 26 months, David had sold their mother's home for $380,000, significantly below market value, in a transaction that was later shown to have been purchased by an LLC that David controlled through a third party. He had withdrawn $210,000 from savings and moved it through a series of personal accounts. He had liquidated an investment portfolio worth $145,000, total assets taken approximately $735,000. His justification, when confronted by Elena, he had paid for their mother's care out of pocket for years before the memory care facility was arranged, and the family owed him reimbursement.
The memory care facility's billing records showed that their mother's fees had been paid directly from her own accounts, not from David's pocket. The records also showed that David had listed himself as next of kin for financial notifications and had removed Elena from the facility's authorized contact list without her knowledge. She had not received a single billing statement, tax document, or financial update from any institution that held their mother's assets. The information blackout had been systematic.
Elena hired an estate attorney and a forensic accountant. The forensic review took 6 months and reconstructed every transaction made under the power of attorney. The evidence was clear: self-dealing sale of real property, unauthorized transfers, commingling of funds. Elena's attorney filed a civil complaint and made a referral to the state's Adult Protective Services Unit. The state opened a criminal investigation. David hired a defense attorney who argued that all transfers were authorized under the POA's broad language and represented legitimate reimbursement for caretaking services.
The criminal case moved slowly. Elder financial abuse prosecutions are complicated by the fact that the victim, in this case, their mother, was deceased and had been cognitively impaired before her death. Her capacity to have understood or authorized the transactions could not be directly established. The defense argued she had approved the transfers verbally. The prosecution could not produce contrary testimony. In 2022, David was charged with elder financial abuse and theft by fiduciary. The case was still pending at time of filing.
The civil case moved faster. Elena obtained a judgment against David for $560,000. The amount the forensic accountant determined was taken above any plausible caretaking reimbursement. Collecting on that judgment was a separate challenge. David had transferred his own real property to his wife before the civil judgment was entered. Most of his liquid assets were untraceable. Elena's attorney filed to pierce the asset transfers as fraudulent conveyances. As of the date of this filing, she had collected approximately $60,000.
The elder financial abuse epidemic in the United States involves an estimated $36 billion in losses annually, according to research compiled by the Consumer Financial Protection Bureau. Most perpetrators are family members. Most incidents are never reported, because reporting means implicating someone the victim or surviving family loved. The legal tools that exist, POA, joint accounts, beneficiary designations, are designed for convenience and trust. They have no built-in protection against misuse by the person who was trusted. If someone in your life holds financial authority over an elderly parent, the most important thing you can do right now is verify, not because you assume the worst, but because the records will tell you clearly what the words cannot. Subscribe.
Next video, the inheritance that disappeared before the funeral was over.